Welcome to Term Talk, the Federal Judicial Center's video podcast discussing this term's Supreme Court opinions with the greatest impact on the lower courts. I'm Jim Chance, Senior Judicial Education Attorney at the Federal Judicial Center. In the next 10 minutes or so, we'll discuss two opinions about the use of expert testimony in criminal trials. Joining me today are Laurie Levenson, Professor and David W. Burcham Chair in Ethical Advocacy at Loyola Law School, and Evan Lee, Professor Emeritus at University of California Law, San Francisco. Thank you both for being here today. Let's start with Smith versus Arizona, decided 9-0 with Justice Kagan writing for the court. Laurie, talk to us about briefly about the facts in this case, and then how Smith's Sixth Amendment right to confrontation was implicated.
Absolutely, Jim. This is a case that focuses on the Sixth Amendment right of confrontation. And as we know, a defendant is guaranteed the right to confront witnesses against them if it's a testimonial situation. In other words, if statements they made outside the courtroom are being used and the defendant's never had an opportunity to cross-examine them. This line of cases comes from Crawford versus Washington. Building on that, the Supreme Court decided Melendez-Diaz versus Massachusetts, and that involved chemical lab reports, that you could not convict somebody just with a lab report brought in by someone who never did the testing, but you needed the person, the analyst who did the testing, to be there to be cross-examined about how they did the tests and the results. Then there was the Burcham versus New Mexico case, and they said again, you cannot introduce lab findings through the testimony of somebody else who is not involved in the testing. And all of that was really establishing the Sixth Amendment right of confrontation in these cases until a case called Williams versus Illinois came along. And in that case, the court made a turn. In a plurality decision, the Supreme Court said it's not a violation to admit a lab report, even though the individual who made that lab report is not testifying. Another expert could use that lab report for their testimony, as long as it's not, quote, testimonial. That left open a big decision and question for the courts. Gee, what is testimonial in these situations? What will experts be allowed to testify?
Laurie's run through the case law that got us here. Smith is a possession case. Tell us about the facts in this one.
Yeah, Smith was charged with illegal possession of drugs after a search warrant produced a substance found in a shed that was later determined to be illegal drugs. The original lab technician was a woman named Elizabeth Rast, and she, of course, produced lab data, some notes, reports, but she then left. We're not told why, but she was separated from the agency that she worked with and became unavailable to testify at trial. So the prosecution got another expert, Gregory Longoni, to testify at trial. He testified about Rast's lab notes, lab data, reports, and then used that to form his own opinion on whether the substances were illegal drugs. And of course, he found that they were. Smith, the defendant, challenged that testimony as violating his Sixth Amendment Confrontation Clause rights. The lower courts in Arizona disagreed with Smith. They upheld the evidence coming in. They said Rast's lab data, notes, reports were not coming in for their own truth. They weren't hearsay. They were merely coming in as a basis on which Longoni, the substitute expert, was forming his own independent opinion. But the U.S. Supreme Court disagreed with that theory and said the lab data, the notes, the reports that were created by Rast had to have been coming in for the truth of the matter asserted.
Laurie, tell us a little bit more about how the court came to this opinion.
Well, the court took a look at the cases it had decided under the Sixth Amendment that go to whether things are testimonial, and said that courts need to look at the primary purpose of that out-of-court statement. Is the primary purpose to create evidence that's going to be presented to the jury and have a different witness be the mouthpiece? Or is there another reason, an administrative background reason? And for that reason, they had to remand this case itself to see what the primary purpose was of the statements. But if the primary purpose was to get lab results in front of a jury done by an analyst who's not testifying, then that runs smack dab against the Crawford rule.
What does this opinion mean for lower courts going forward?
Well, I think it means that generally the expert reports by a lab analyst who's not testifying will not be admitted, and that the prosecution is really going to have to show that the primary purpose is not to get those reports in for those findings, but for another purpose, which may be a bit challenging. I think this decision is helpful in saying that in Williams, we were not changing our whole opinion on how the right of confrontation works, that in fact, experts can use hearsay, you still have to look at the Sixth Amendment.
I understand. All right, let's take a look at Diaz versus United States. This one's also about the use of expert testimony, but this time under Rule 704B of the Federal Rules of Evidence. Evan, why don't you tell us about the evidentiary rule and how it applies to this case?
Sure. Federal Rule of Evidence 704B prohibits expert testimony concerning a defendant's mental state or mental condition when that mental state is an essential element of the charged offense, or when it's an essential element of an affirmative defense that's being asserted in the case. Here, Diaz was caught transporting illegal drugs across the Mexico border to the United States and charged with knowingly transporting drugs. She said, I didn't know. I didn't know there were drugs in the vehicle. They turned out to be hidden in the door and under the floorboard. Now, the prosecution brought in an expert to testify that most people in this situation, most couriers, know that, in fact, they are transporting drugs. And the reason is that people in the illicit drugs business find it generally too risky to entrust drugs to a quote-unquote blind mule. But Diaz was convicted and appealed on the grounds that allowing such expert testimony did violate 704B. The Supreme Court held that the expert's testimony in this case did not violate 704B, said that so long as the expert was testifying that most people in this situation know that they're carrying drugs, that wasn't the same thing as saying that this defendant knew she was carrying drugs.
All right, Laurie, this is a 6-3 decision with Justice Thomas writing, joined by the Chief, Justices Alito, Kavanaugh, Barrett, and Jackson. And dissenting was Justice Gorsuch, joined by Justices Sotomayor and Kagan. Can you take us through the reasoning of those opinions?
Yes, the reasoning goes back to just learning about how this rule came into existence. Under common law, you could not have experts testify about ultimate issues in the case. When the Federal Rules of Evidence got adopted, that changed. So under 704, experts can testify regarding ultimate issues with one narrow exception. And that exception is the one that Evan was referring to, that an expert cannot testify as to a defendant's mental state if it's an element of the charge or a defense. So here, when Diaz is needed to have as an element whether she knew she was transporting the drugs, an expert would not be able to testify to that. The question was whether when you have an expert that says most people would know, that's the equivalent of saying she knew, and that would be prohibited. The Supreme Court, a majority said, no, we're going to construe this exception very narrowly. Saying that most people knew is just educating the jury on how these drug schemes might work, and they can ultimately decide whether this defendant knew or not. They were referring back to where this exception came from, which was the infamous shooting of Ronald Reagan by John Hinckley, and not wanting experts to talk directly to what Hinckley's mental state was. So the court took a broader approach. and said, generally, let's let the jurors hear this evidence and then they can decide. And that's what the majority held.
So Justice Jackson was in the majority, but she wrote a separate concurrence. What did she say?
Well, she wrote an important concurrence because what she said is if the prosecution can use evidence like this, the defense can as well. And you can imagine a case that involved a battered person syndrome where the defendant is claiming, this is how I was thinking, this is what I was doing based upon the circumstances of where I was in. And the defense wants to call an expert to say, this is what most people who are in this situation will think or do. So she was making very clear that if we're going to have this approach, it has to be neutral. You could have these experts testify, but they can testify for either side.
Evan, the dissenters weren't persuaded by those arguments. How did they analyze this differently?
Justice Gorsuch wrote on behalf of the three dissenters, and he felt that the majority was blinking away reality here. He said when an expert witness comes in and testifies that most people in this situation know that they're carrying drugs, that's not meaningfully different from saying probably this particular defendant knew she was carrying drugs. He said that there are intractable line drawing problems here. The majority did concede that if the expert in this case had testified that all drivers in this situation know that they're carrying drugs, that would violate the rule. Justice Gorsuch then said, well, suppose that an expert testifies that virtually all drivers in this situation, almost all drivers in this situation, and so on and so on. And he said it's an impossible line drawing problem. He said, look, when you have an expert testifying about what most people are thinking, that's what he termed expert evidence in mental telepathy. And he said, mental telepathy's got to be the junkiest of the junk sciences. And why are we going here? He urged lower court judges to use other rules to exclude evidence like that. For example, relevance. That's a tool that lower courts can use to exclude such evidence. Lower courts can say, that the potential for prejudicial effect substantially outweighs any probative value, and so on.
Laurie?
And I think that the court also has the responsibility to make sure that you have an expert who's qualified under those Daubert standards. Since when can someone, just because they were an agent, stand up there and say what most people think or most people know, or even how most of these groups operate? So I do think there are tools for the lower courts, but what the messaging is in this case is that the court is broadly allowing experts. They want the jurors to hear information. The jurors will make the decision, and the judge can decide in each individual case whether it merits presenting it.
Laurie, Evan, thank you both for joining us today and for sharing your expertise.